appeal in the matter of Heath Chiswell Green and Secretary of State for Levelling Up, Housing and Communities, Elisabeth.
Yes, Mr. Elisabeth.
My ladies, my lord, good morning. I appear on behalf of the appellant, my learned friend Mr. Simons for the Secretary of State, Lord Bannon, Mr. Henderson for the second respondent, and Mr. Stitchcombe for the third respondent. The fourth respondent is not here today and has not taken part in proceedings.
We should tell you that we have done our homework. We have read very extensively into the papers, and so you can assume that we're pretty well familiar with the issues.
I'm very grateful, my lady, for that indication. If I may just raise one minor typographical error with the bundle.
Yes.
In relation to the supplementary bundle at tab 4, and this is perhaps the most easiest to show by reference to the index at tab 4. The index. My apologies for this chronological mix-up. The third respondent's further response, which is the second item, appears before the third respondent's response, which is the last item. Those two have just been mixed up, and my apologies for that.
Okay.
But the third respondent's response comes first in general. This appeal concerns a question of law on which there is no previous direct authority, which is whether the appellant is permitted to run what's known as a Kydes argument about the failure for a decision maker to take into account a material consideration that arises after the hearing of an appeal, where they did not expressly raise the material consideration to the decision maker themselves, or whether they're procedurally barred from doing so on the application of the principles in West and Mead. And the appellant would submit that there is, on the way in which the learned judge below dealt with the matter, a tension between those two lines of authorities, although the appellant will submit today that properly interpreted there is no tension between them. There are two grounds of appeal. The first relates to the fact that the learned judge was wrong to find that Westmead operated as a preliminary procedural bar preventing the appellant from relying on Kydes. And we say that is properly primarily a point of legal principle. And the second ground is that the learned judge was wrong to find in the alternative that the Arup review was not so obviously material as to be a mandatory material consideration and meet that first element of the Kydes test. And that is primarily a matter of a factual matter applying to the facts of this case.
If the factual matter were to be determined in a certain way, this court wouldn't need to resolve the first issue, would it?
Well, the issue is that the way in which it was dealt with below, the first matter was dealt with as a preliminary procedural bar,
Yes.
which, as it were, prevented us from even being able to run those arguments.
Yes, but if you were allowed to run the argument and if you were wrong on it, then we wouldn't need to decide the procedural point at all.
That is correct in relation to the dismissal of this case.
Yeah.
But it would, of course, have we say, wider relevant legal effects that it would be useful for the court to clarify in relation to whether
How often do we get Kydes type arguments arising? Pretty rare, aren't they?
Well, they have arisen in terms of the context of a local authority level.
Yeah.
They have arisen in cases such as Hardcastle and such as Hale Town Council, and there are two examples at least that we could find at the appeal level, the Wayne Holmes case, and these. So it has occurred enough, we say, to create lines of authority in relation to it.
All right.
The court has helpfully indicated that they're familiar with the facts, and therefore I will not dwell on them too long. If I may, though, with the court's permission, just emphasise a few elements of the factual background which relate primarily to ground 2. these were two sites within the Green Belt, and there were two Green Belt reviews which were relevant to the appeals. The first is what's known as the SKM Green Belt Review, which was carried out in two stages. The first stage in 2013 identified 8 strategic areas which contributed least to Green Belt purposes, and both the appeal sites fell within sub-area S8. This was then followed by the second stage SKM review, which examined those 8 areas in further detail, and in relation to sub-area S8, it found that it was the most suitable site for development, most suitable site for potential release and future development. That was the finding that came out of that, and that was the finding which the Inspector and the Secretary of State found was an important consideration. The SKM reviews were part of an emerging local plan process in 2018, but that process was abandoned partly due to criticism from the examining inspectors. That criticism is what triggered the 4th respondent to commission the Arup review. The Arup review was published on the 16th of June 2023. That was a month after the inquiry had closed, although within the inspector's report there is acknowledgement and a reference by the inspector to its imminent publication. I won't take the court to it, but that's at paragraph 300 of the inspector's report, at page 61 of the supplementary bundle.
Can you just briefly outline the stages that it'll have to go through before that Arup review turns into or is incorporated in a local plan? Will there be consultation and an inquiry by an examiner?
Yes, of course, my lord. So the Arup review itself was a final report. It was, as it were, published, and it formed part of the evidence base of a local plan process. Your lordship is right.
By the local authority?
The Arup review was commissioned by the local authority, yes. That local plan process would have required further consultation, but not on the report per se, but on the local plan, which the report is part of the evidence base for.
So there'll be further consultation on the plan?
On the local plan.
On the draft local plan?
On the draft local plan. That draft local plan would then go to examination, and I understand that is the process that's currently ongoing. Some examination hearings have been held into that local plan, but that
examination by an inspector appointed by the minister or the local
yes.
authority.
By the Secretary of State. And then, as I understand it, we're in the middle of that process, and then a recommendation will be made by that inspector to the local authority as to whether to adopt, and then it's for the local authority to adopt the plan.
Thank you very much.
That is the same status that the SKM reviews also had. They were part of an evidence base of an emerging local plan process that never finished, because the plan was that version of a plan was abandoned. If I may take the court to the Arup review just briefly, and to in the supplementary bundle, page 183. Sorry, 183. Where there appears a heading Implications for Stage 2 GBR. And this is a useful paragraph because it explains the purpose of the Arup review. The first point to note, the first paragraph under 3.5, is discussing the relevance of the first stage of the SKM review. And it notes at the end of that first paragraph that the recommendations of the SKM Stage 1 review on the weakly performing areas therefore provides a good starting point for this Stage 2 review. And the reason I take the court to that reference is a submission, I think, by certainly the first respondent is, well, the first stage SKM review wasn't totally superseded, it remained relevant. And that is correct, but it only remained relevant as the starting point for the Arup review.
Well, that starting point is that the 8 areas identified, which include the 2 appeal sites, are within the Green Belt area as a whole the most suitable for consideration for release. The next stage is which of those 8 areas are considered the most suitable for release. Is that correct?
Well, if I may, my lord, the first stage review said these are the 8 weakest performing areas.
Yeah.
It didn't rank them or analyse which, as it were, was the weakest.
Exactly. So the first bit, but they said they were the 8 weakest areas, presumably by comparison with all the rest of the Green Belt.
Yes, but what was a distinction between the second stage SKM review and the Arup review? The second stage SKM review limited its scope to those 8 areas. The Arup review, and this is set out just in the next few paragraphs, didn't limit itself to those 8 areas, but also looked more widely at the rest of the Green Belt. And that point is shown by the 3rd paragraph of 3.5, where it notes this stage 2 Green Belt review, this being the Arup review, takes a more comprehensive and granular approach to identifying potential sub-areas to assess within the Green Belt. Not only does it reconsider the weakly performing strategic sub-areas and sub-areas identified in the stage 1 review, but also opportunities for potential release in the wider Green Belt. So it is stretching its geographical scope back out, as well as revisiting in more granular detail those areas identified in the stage 1. And it is also noted here that the SKM stage 2 review is entirely replaced by the newly commissioned Arup review. That's in the 2nd paragraph under 3.5. And that was a point that was illustrated. I don't need to take the court to it, but it's illustrated by the 4th respondent's website, which labels the second stage SKM review as superseded. If need be, that
Where is that in the evidence before us? I didn't see the website in the evidence.
315, page 315 of the supplementary bundle.
Thank you. Oh yes, I did see it. So what am I supposed to be looking at?
My lord, there's under Green Belt Reviews 2013 to 2024, there's partly superseded, and that is a reference there under partly superseded to the stage 1. There is then superseded, and the first line there, Green Belt Review Sites and Boundaries Study, February 2014, is the stage 2.
Thank you.
And the Arup review therefore abandoned the wider 8 sub-areas approach and instead identified 183 sub-areas to examine. Appeal A site was identified as SA 139 and Appeal B as SA 140. And the findings in relation to SA 139 was that it was a moderate overall performer making an important contribution to the wider Green Belt and was not recommended for removal. And if I may, just to illustrate this point as to the options that the Arup review was looking at, take the court to page 236, and it's a table, and I think it illustrates the point well from the Arup review. And what this shows just in the headings is in terms of the recommendations that the report can make, there were 4 potential recommendations. Not recommended, recommended in isolation only, recommended in combination only, and recommended in isolation and or in combination. That's referencing released in combination or in isolation. So it's the depth of its analysis is going further into looking at whether sites should be released on their own or in combination. And both SA 139 and SA 140 are not recommended for removal.
I can see 140 in the table. Where's 139?
The format of the table is it starts with those that perform overall strongly, and that's why on that page your ladyship can see 140. If your ladyship turns the page to 237, where there are moderate performers but they still make an important contribution, that's where 139
Yes,
is.
thank you.
And if I may just take the court to page 235, so just a page back, because it's relevant also that while the report didn't recommend either of these sites to be released, the overall recommendations were, and they're set out at 5.9, that 54 sub-areas have been recommended for further consideration in isolation, and 29 sub-areas had been recommended for further consideration in combination, i.e. the Arup report identified 83 other areas which should be examined for green belt release and for future development. And while I don't wish to take too much of the court's time on this, as well as this summary, this high-level summary as to the findings, the Arup report did have detailed analysis of both sites because both sites were given their own sub-area categorisation. And if I may just take the court to one and then give the court the reference to the other to show the detail that was provided within there. If I may take the court to page 307 in the supplementary bundle. And this is the more detailed assessment for sub-area 139 or the Appeal A site. And just to note that it is an assessment over 4 pages. It runs from 307 to 309, examining the contribution of the site to the various greenbelt purposes, and then coming to an overall summary, which is at page 309, at the bottom of page 309. Overall, the sub-area plays an important role with respect to the strategic land parcel, and its release in isolation or in combination would harm the performance, and then the overall recommendation at 310. May I just ask the court to note, I can take the court through it, but a similar detailed analysis is found at page, well, just the next consecutive pages, 311 to 314 in relation to SA 140. The inquiry closed on the 9th of May. The Secretary of State recovered the appeals on the 1st of June. And as I say, the Arup review was published on the 16th of June. On the 18th of January 2024, the Secretary of State wrote to the parties. And
before we get there, I've seen a reference to the appellant commenting or making representations in September about the what were they doing in September?
So in September,
the judge says that the Chiswell Green must have known about it because in September they commented about it.
I think that's right. Yes, my apologies, my lord. That is in relation to, it was our consultation response to the draft local plan exam.
Right. So in September, the appellant responded to the draft local plan, of which this was part of the evidence base.
Yes.
So they knew this when they responded.
Yes. And they were responding to, as it were, the publicly available opportunity as part of that plan exam.
So there's no dispute they knew about the Arup document in September 2023.
Yes, ma'am.
Thank you.
So on the 18th of January, the Secretary of State wrote a letter to the parties, and this letter can be found at page 316 of the supplementary bundle. And this asked the parties to provide their views on the revised MPPF that had been published in December 23 and the housing delivery test figures in 2022. And there are two relevant points that arise from this letter. The first is that it is recognition by the Secretary of State that there are considerations that can arise between the end of an inquiry and a formal decision, which can be material and need to be taken account of, because that is what the Secretary of State is doing in relation to the MPPF and these housing delivery figures. They are making the parties aware they could be material and seeking their views. The second point to note from this letter is paragraph 5, this is where it is the instruction is given that comments should be confined to any new matters arising from this new material, i.e. the December MPPF and the housing delivery test figures, and should not seek to raise any other matters. And the reason this is relevant is to deal with the point which the learned judge below, of course, found and found to be detrimental to our case, which is it is accepted that the appellant did not provide the Arup review to the Secretary of State. The explanation is that they were being unrepresented.
Can you take us to the evidence, please? Not your statements of why they say that they didn't send it. Could you take us to a witness statement or an extract from a witness statement which says, I didn't know, none of the people in the organisation knew that we could have sent it in?
Yes, so look, I noted that witness statement, there were two witness statements, they were presented to the court below. I'm not sure, I know an extract has made its way into the supplementary bundle. I'm not sure the entire witness statements have done. No. They were recognised by the judge, but by the judge below in terms of what they were saying. The judge found that explanation to be inadequate.
Well, we can't work on statements made by counsel. We need either to look at the statements or we have to accept what the judge says. So an explanation they didn't appreciate that they could have done something between September and January is unlikely to be of great assistance unless we've got the material to show that the judge was wrong, and you're saying we don't.
My lord, I think the judge recognised that was the explanation set out in the witness statement, but she said that it was inadequate, as in it didn't justify us not providing it.
So that's that.
I'll take your lordship to it.
There's a court of law which must proceed on evidence.
Yeah, of course.
Yes. $75.
Yes, my lord.
And she says it's inadequate. I don't see any reference to the evidence that is put forward to support what is said to be an explanation. I think we do need to have the statement backed by the statement of truth, which says,
yes,
I didn't realise I could do this. Otherwise, we've just got your statement.
Of course, my lord. I'm just reviewing whether it's referenced in the by the judge in the facts, because your lordship certainly has an extract of it. I know that.
Well, I got two extracts, I think, from Miss Ledger. Anyway, it's a matter for you to deal with as you wish, but a statement not backed by evidence is unlikely to be of much assistance.
Of course, my lord, I recognise that. If I may explain why, and it's something I'll take instructions on as to whether we can ensure that that's provided to the court. The reason perhaps why it's not is we read perhaps wrongly, but we believe that the learned judge didn't, as it were, doubt the veracity of the statement made to her. It's that it was, legally she didn't find it was an appropriate explanation as to why, in effect, the Westmead principle shouldn't be disapplied and we can rely on guides. Our submission primarily is whether or not the explanation is inadequate as a point of law. We say that it shouldn't have been determinative of the.
I understand that, but you just took us to paragraph 5 of the letter which said you can't make any comments.
Yes.
And I'm concerned of the period between September and the 18th of January. And if it is said the reason why they didn't do anything before they got the letter was because they were in a state of lack of awareness of that, then there needs to be evidence of that. You can't simply say something to a court without.
Of course.
Just to insist that the
That's where we
paragraphs in
are.
the judgment, the paragraphs in the judgment are in fact 75 and 76, which deal with, to the extent it's dealt with.
This is a slightly different point. If they had a planning advisor, then it'd be very difficult to say they didn't know. They had one, they say, at the start, and then they put their money for the transport person, whose name escapes me. But this is a different factual question. Did they or did they not know at any stage in September and the 18th of January that they could or couldn't send the report to the minister? That's the only question.
Yes, my lord, and it is, and I appreciate a witness statement that is not before this court. It was before the court below. It may be, if we may, that we can provide that witness statement.
There is a witness statement that was in evidence. It would be helpful on this issue.
Thank you, my lord. I'll see if we can arrange to do that over this morning.
They just chucked in.
My lord, we're going to arrange for those to be printed out and handed up either over lunch or if
That would be very helpful. We're very grateful. Thank you very much.
But what in this letter, at least from January, what they were being told was that in terms of the opportunity to raise new points, they were limited to the two matters that were in that letter. And that is reflected in terms of the appellant's understanding that that was the case. That is reflected in the response that the appellant did send to this letter, which is found at supplementary bundle page 325. That's where it starts. This was the response that the appellant made. And at paragraph 2 to 3 of that response, the appellant notes that, and again, this was written, as it were, by the appellant, not by a planning professional, not by a lawyer or legal representation. Paragraph 2 notes, the response deals with the comments submitted by the appellants in relation to the MPPF and HDT figures. Both appellants, the reference to the second and third respondent, have commented outside the remit above, and our lack of response to their comments on subjects outside the requested areas does not imply that we are in agreement with them, nor that we attribute any veracity or validity to those comments. So that is, as it were, the appellant reflecting that they're just following the instructions they've been given by the Secretary of State's letter to just comment on those two matters that they were asked to provide their comments on. And why we say that is relevant is because, other than unilaterally sending the Arup report to the Secretary of State, this was the only invitation from the Secretary of State for further representations to be made.
But if nothing had happened after the inquiry had closed, and certainly after September when they got it, the position was a blank sheet. If they didn't know what to do, they could have written and said, there is this thing, can we send it to you? Or they could have sent it. Then you say, on the 18th of January this letter was sent, and then you infer from that that they believed that it was no longer possible for them to send it in. It seems to be the gist of your submission.
Or that this wasn't the ability to do it. they couldn't send it here because they were asked purely to comment on two.
Which explains what happened after the 18th of January, if it doesn't use September to January.
It doesn't matter, and I appreciate that is what's in the witness statement, and I will, rather than I appreciate tell your lordship what's in it, I will make my submissions once your lordship has it on that point. In terms of the correspondence from the second and third respondent, in relation to this letter, they did both make reference to the Arup review, and it was this correspondence that led the learned judge below to conclude that the Secretary of State did have knowledge of the Arup report, that the second element was met. Just to highlight a few elements that come out of that correspondence, it noted the Secretary of State was made aware that the Arup review arrived at different conclusions to the SKM review. That can be found at page 347 of the bundle. And this is the third defendant's January 24 letter to the Secretary of State. And the first bullet point on that page is noting that despite assuring the inquiry of the veracity of the SKM Green Belt review, the Council is now informed by a second Green Belt review, which identifies different sites for consideration. And the Council will have to explain why SKM and Arup have arrived at different conclusions and which should take priority. They were aware, sorry, when I say there, my apologies, the Secretary of State was aware from this correspondence that, turning to page 334, which is the second respondent's letter, and at the end of that letter, they were aware that, and this is responding in fact to the third defendant's comment, the last paragraph of that, or second last paragraph of that letter, is noting that if any reliance is to be placed upon these comments, being the Arup comments, the inquiry would need to be reopened so that they could be the subject of cross-examination, may result in an application for costs. Reliance upon the Arup review without giving the appellant the opportunity to cross-examine would be unlawful. So was aware that it could be material enough that if it was...
Need to read the paragraph above.
Oh, no, the Parker comment. Yeah, sorry, these were in response to the Parker comments. Yeah, sorry, I thought I'd said that, but if not.
But you say that they were saying that they needed an inquiry and so on. The whole thing is you should disregard it, because if you don't, you need another inquiry.
Yeah, yes.
Well, different.
My apologies, my lord, but recognising that if reliance were placed upon it, it was material enough to potentially require the inquiry to be reopened. And then just in terms of the detail that the Secretary of State was aware of from the Arup review, it wasn't just about its existence. If I take the court to 321, which is the third defendant's further response.
331?
Supplementary bundle page 321.
These are not in chronological order. It's very difficult.
No,
It took a long time to work out the sequence of events.
my apologies, my lord.
Anyway, so 321. And this is now February 2024. There's no date, but the earlier paragraph indicates it was sometime before the 12th of February.
Yes. And this is where there's a reference to the fact that the site south is no longer the performing site, and that the Arup report concluded this is a bit of crossfire between the second and the third respondent, that the Stantec site was now not recommended for further consideration. Noting as well that the footnotes are drawing the Secretary of State's attention to specific paragraphs within the Arup review. Footnote 9 and footnote 10 are both making specific cross-references.
Any relevance to paragraph 13?
Yes.
They're not referring, which is what I mean by referencing, to give any weight to the draft allocation, because they say that is as flawed as the earlier one. It's just that they think this is a poor authority.
Yes. They are. I'm not suggesting that the second and the third respondent are saying necessarily this is a word changes everything, but they are raising points. They're also raising what would have been their response to them as well. That they are making the Secretary of State aware, factually, of the presence of a new Green Belt review, the fact it contradicts the Green Belt review, which of course the parties didn't know this at the time, but which the inspector had placed as an important consideration. So the knowledge is not just the existence of a document, it's also that its conclusions could be relevant to the consideration before the Secretary of State. Because if it assists to summarise what the real difference between the SKM review and the Arup review was, the SKM review was concluding that these sites lay within the most suitable area in the district for Green Belt release and future development, compared against a smaller pool of 7 other strategic areas. The Arup review was saying, well, there are in fact 83 other areas that are more suitable for Green Belt release and development. And so the Arup review and the SKM review are coming to directly opposite conclusions in that respect. That's the relevance of the difference between them at a high level. Turning then just briefly to the inspector's report and how the inspector treated the SKM review, if I may take the court to supplementary bundle page 97. And at paragraph 531, this is really the start of 3 key paragraphs. The inspector's looking at the SKM review, noting in the first few lines that it was involved with the plan-making process. It's not for the purposes of these appeals, it's some years old. And for these reasons, its conclusions cannot be directly applied. However, the inspector says, the Green Belt review is clearly a material consideration relevant in considering Green Belt matters, notwithstanding that the local plan has been withdrawn and attracts no weight. I've had regard to the Green Belt review reaching my conclusions. And just to pause there, why I say that passage is relevant, particularly relevant for ground 2. The respondents and also the learned judge below, one of the reasons for dismissing the relevance of the Arup report was that it was part of an emerging plan process. That process hadn't finished. Its role was different. But the response to that is, all of those points applied equally to the SKM review were recognised by the inspector expressly, but didn't prevent the inspector not only finding it a material consideration, but going on to find it as being an important one. So if those points, as it were, didn't prevent the SKM review from having weight, it can't be said that they prevent the Arup review. The SKM and the Arup review are similar in their nature.
And that was a matter of planning judgment for the inspector. So that's a classic example of a material of the inspector using planning judgment to decide what is material and what isn't. There's a world of difference between that and saying it's a mandatory material consideration. So you're comparing apples with pears, it seems to me.
Well, my lady, if I may try and address that further, although I'll return to it in later submissions, we'd say in terms of the 2 reports, they're not apples and pears. They are doing the same thing and having the same function. And when we come on to CIDES, the test is whether it's so obviously material to be realistically capable of causing the decision maker to come to a different view. And what we say is, if one report was taken into account as an important consideration, the same nature report which supersedes it and comes to directly opposite views, we would say must be said to be realistically capable of causing the...
There's a break in the chain of logic there.
One report is material, a second report, the same purpose that supersedes it, is what, can you just give me that submission again?
Of course, madam.
If one report material, a second report,
So if one...
superseding the first for the same purpose, yeah?
If one report is material, the report that replaces it and is of the same nature, i.e. a report that forms part of an evidence base of a local plan, is also material.
Yes, in other words, you're saying if the Arup report had been available at the time of the inquiry, it's likely that the inspector would have regarded it as a material consideration.
Yes, and disregarded the second stage SKM report because it had been totally superseded.
It would have been unlawful for him to do that. The question is it unlawful for him not to have regard to the Arup report? That's the question. Would it be irrational to say, I'm not going to use the Arup report for the decision that I'm taking? That's the key question.
And my lord, if I may, if the Arup report had been raised at the inquiry and debated and the inspector had said, well, actually, I'm going to disregard that, I'm going to go back to the SKM report that was superseded, there would have been an argument that that was an irrational decision to make. And we say, perhaps, that by the time you get to the decision, that knowledge was with the Secretary of State at that time. The Secretary of State knew that the SKM review had been superseded and the Arup review had replaced it. And that's where the only difference is in time, and that's where Kydes comes in, those arguments come in. What's relevant is what the inspector and what the decision maker drew from the report that they viewed as being relevant, and that's at 532 and 533, where the key factual point that the inspector drew from the SKM review is that both sites fell within the strategic sub-area S8, and noted that of the strategic sub-areas it was ranked in the first position, the most suitable area in the district. Then 533, which follows on, and in brackets 532 is referenced as the part of the logic as to why this paragraph is written. The council accepts there will be need to be a significant amount of development in the Green Belt if the housing requirement is to be met. That being the case, the relative suitability of sub-area S8 is an important consideration. And if I may just briefly expand on well, what is the important consideration the inspector is finding there? It's a strategic point that is separate from the site-specific analysis in relation to the specific harm to Greenbelt that the inspector will go on to look at in relation to the two sites. The point is, to meet housing need, this council accepts that development has to go somewhere in the Greenbelt. And the SKM review is telling the decision maker, this is the most suitable area for it to go. And the reason why that understanding what the important consideration was is critical is because, first of all, we'd submit that conclusion couldn't be made on the Arup review, because it's saying there are 83 other areas which should be looked at. This isn't the most suitable area to go. And secondly, it's a response made by the respondents, and also it was the third reason why the learned judge below dismissed our case in relation to Kydes, of that we can't challenge the inspector's judgment on the specific consideration of very special circumstances, which was based on a formal site visit and conclusions of harm. But the point is, the important consideration is separate from those site specifics. It is feeding into a strategic point, which has nothing to do with the actual harm that will be caused to these sites, which is, as I say, housing has to go somewhere, and the SKM review is telling me this is the best place for it to go.
And just so I've got it clear, the reference to the relative suitability of sub-area S8 is a reference to stage 1, because that's the one that identified S8. Is that right, or is it not?
So the reference to falling within strategic sub-area S8 is that first line of 532 could be said to be a reference to stage 1 as it identifies it. Everything else that follows is stage 2.
Wait, hold on.
It's a
So the reference at 532 is both appears fall within the strategic sub-area S8. That's stage 1.
could be said to be stage 1 because it identifies those areas.
Yeah. It's a tier 1 site. Where does that come from? Is that
That's stage
breaking
2.
down? That's stage 2.
That's
So it
stage
can
2.
only be stage 2 because stage 2 refers to that. And then when you get back to 533, the relative suitability of sub-area S8, and you say that incorporates the reference to S8 and tier 1 within S8.
Yes, because it's also the last line of 532. Out of the strategic sub-areas considered, it is ranked in first position the most suitable area in the district. That's a conclusion of the second stage.
I'm thinking of it like this. S8 is the strategic area of the whole. Within S8, you've got a number of different areas. Are they ranking within S8? Which areas within S8 are the best and the worst? Or are they ranking S8 against other areas?
Yeah, they are ranking S8 against other areas of the other 8 areas. But if I may assist further, and I can take your Lord to it if it would assist.
So they're ranking S8 against S1 to 7.
They identify 7 other sites. Now, if I may, and I this point was discussed in the court below. It didn't feed into her ladyship's judgment. I can assist. There's some slight uncertainty when you go to it about whether S8 is talking about a particular area of S8 or both parts of S8, because there's discussion about one area being more sensitive than the other. But the point is the inspector is treating it as S8 being the most suitable area in the district against these other 7.
Yes. So areas within S8 are more suitable than areas within S1 to 7.
And it's fair to say, because I'm sure that the second, let me get this the right way round, the third respondent site was less vulnerable or less suitable than the second.
We get that from paragraph 550, yes?
Yes, yes, exactly. But this is not, as it were, a site-specific analysis at this stage. This is looking at the wider.
So this is a strategic one, and it's based on the view of S8.
In the second stage review, that view is not put in the first stage. The first stage.
I haven't understood that. I want to know what these paragraphs are concerned with. I'm just trying to get to the bottom of the facts, that's all. And I just thought we'd had a discussion where I thought you had told me that these paragraphs are comparing areas within S8 strategically against areas within S1 to 7. I didn't understand you to be saying these paragraphs relate to a ranking of areas solely within S8 as against each other.
That's correct.
That's correct. So it's just the stage 1 S8 against the others. Yeah, thank you.
But I'm sorry, I think you've got the point. But that ranking only occurs in stage 2.
I don't understand that sentence, and I'm afraid it's my fault.
No. It's my fault for not explaining it clearly enough. Perhaps stage 1, the review, simply identifies 8 of the weakest performing areas across the district, and it says these should be looked at in more detail. Stage 2 then looks at those 8 areas in more detail, and then stage 2, the separate report that happens a year later, that's when it ranks them as to most
Right then, ranks what?
The strategic areas.
My current state of knowledge, which may be wrong, is that these paragraphs deal with a situation where you are comparing areas within S8 with areas in areas 1 to 7.
Yes.
If there are 6 areas within S8, it is not ranking those 6 areas.
That is correct. But I was just, that exercise is carried out in the stage 2 report.
So that exercise, what exercise?
The ranking exercise.
The ranking of
S8 against the other 7 areas.
It might assist.
Yeah, I can. If I take your Lord to the
Of 158 in the supplemental bundle, you see the ranking that's being discussed.
yes. So this is an extract from the second stage SKM review.
So this is the 8 areas within S8 that are being ranked, or whatever number of areas.
No, not within S8.
No, these are
These are all of them.
these are the 8 areas.
These are the 8 sub areas.
These are the 8 areas, and you've got area 2 is divided into 2A and 2B.
Yeah.
So until we get to the second review, are you telling me that we don't know that S8 is the one that's weakest?
Yes.
Okay.
My apologies, my lord. That was my fault entirely for not being clear enough.
The first stage identified the 8 areas. There's only the second stage that says S8 is the weakest. Thank you very much. Apologies, my fault. It's just getting to the bottom of it.
No, I should have perhaps taken you. The table is better than words. My apologies.
We've got it now, yeah. So going back to the report. The reference and relative suitability of S8 must be a reference, then you say to stage 2, because that's the stage to which the
Yes.
relative rankings are given. Okay.
So the inspector recommended that very special circumstances existed, permission be granted, and the Secretary of State's decision letter, which is the formal decision we're challenging, agreed with that recommendation. And
Before we do that, there are site-specific things, and not on Appeal A, you've got 542, which talks about it being notable that that appeal site was within the least sensitive part of the sub-area. And then at 550, the inspector says the review draws a distinction between the east and west parts of S8. And he says this accords with my own findings that the green belt impact would be much greater from Appeal B. He seems to have made his own findings about the harm in relation to Appeal Site B at least. And he says that accords with the GB review rather than that the GB review has driven that conclusion. Or is that a misreading?
no, my lord, I think that's a fair reading, which is he's exercised his own judgment, and it accords with that element of the review. But that is that is the inspector considering a separate point about the site specifics,
Yes.
rather than the
Strategic.
And if I may just take the court to the decision letter, which is at 339 of the core bundle. And paragraph 17. This is just to note that, because of course this is the formal decision we're challenging, that was something that the Secretary of State followed and agreed with the recommendation. It's noted though, paragraph 17 is making a specific point about the Green Belt review. It's highlighting it, that not only does the inspector, the Secretary of State, agree that it is a material consideration considering Green Belt matters in the district, and the relative suitability of the strategic sub-area as defined by the Green Belt review is an important consideration. So the Secretary of State is picking up on those very particular conclusions and endorsing them, agreeing with them, making them.
Yeah.
Unless I can assist the court any more on the facts, and I heard that wasn't too extensive, I will turn to the law. Legally, at the heart of this case, it's a consideration of the statutory duty on the decision maker to have due regard to material consideration. As set out in my skeleton, that's found at section 72. It applies to these type of situations via section 79(4). And I'm at paragraph 27 of my skeleton. The nature of the duty was explored in the Friends of the Earth, and there's no dispute as to those principles, of course, and that we're in the third category, as your ladyship has noted, of a consideration that's so obviously material, albeit that is applied in a KIDE's context in a particular way.
And Friends of the Earth appears to say that whether it's so material is to be determined by applying a rationality test. That's in
Yes,
the other part.
absolutely, my lord. Yes. The aspect of the duty which concerns this appeal is how the duty relates to when a material consideration arises after the hearing of an appeal but before the decision is made. And the leading case on that, we say, reminds that of the Kides case. If I may just briefly, because it's a point taken by the first respondent that Kides can be factually distinguished from this case, it is right to know on the actual facts of the case that is correct. Kides concerned when to take an application back to a planning committee who had resolved to grant permission, but a material consideration arose before the formal decision notice was actually issued. And of course, in this case, we're dealing with it between an inquiry closing and the formal decision. But we would say, and the learned judge below seemed to apply it to situations like this, the principles at play are the same, which it concerns the scope of the statutory duty that applies where a material consideration arises between a public hearing and the internal formal decision that comes out of it. In Kides, it was an officer with delegated authority. In this case, it's the Secretary of State on recommendation from the inspector. So we say that Kides is an appropriate place to start in relation to this principle. And the Court of Appeal in Kides concluded, and Kides is found at tab 3 of the authorities bundle, and concluded at paragraph 123, which is page 55 of the authorities bundle, 123 of the judgment starts by introducing that context, and Kides strikes the balance as to what happens. At 124, it notes at one extreme it cannot be a sensible interpretation to conclude that an authority is in breach of the duty to consideration the existence of which it did not discover or anticipate and could not reasonably have discovered or anticipated prior to the issue of the notice. So there has to be some practical flexibility in excluding from the duty material considerations to which the authority did not and could not have regard to. And the reason I just go to that paragraph in particular, the court is recognising building in practical flexibility. We're going to come on to consider practical implications that flow from if the appellant is right in terms of what has to happen to the inquiry. But there is already building within this some practical flexibility, that it won't just be any material consideration that could possibly arise. And the court is recognising that. And they then note on the other hand, of course, that where a new material consideration, this is just paraphrasing 125, where a new material consideration arises that the authority should have regard to, then they must regard to it or reconsider. And if the authority fails to do so, they'll be in breach of their duty. So this establishes that duty on the decision maker to have regard to material considerations exists up to the date of the decision, where they were aware or ought to reasonably have been aware of a new material consideration. And Kides has been considered and applied in a number of cases. We rely on
your situation is actually stronger. There, they'd actually resolved. They still had to go back, even simply because the decision notice hadn't been issued, and that could be because he was off ill or he was waiting for Section 106 agreement. You say this must be stronger, logically, because there's no decision at all yet.
I think that's fair, my lord. Yes. And we rely just on the useful summary of this in the Hale Town Council case, simply because in Hale, Mr. Justice Laing boiled it down and reflected that there are really two elements to the Kides question. The first is, and I'm at paragraph 34 of my skeleton, but if I may take the call to page 365, the authorities bundle. And at paragraph 45 onwards, what the court is doing is recognising, in fact, an earlier decision of SoS, Cranston and Hardcastle, but that the Friends of the Earth material consideration approach is reflected, can be reflected in kinds, in that, in terms of the first question, and it's the quote from Sir Ross Cranston at paragraph 36, the question is whether a rational decision maker would regard a new consideration as so obviously material if it was realistically capable of causing the authority to reach a different conclusion. And so that is the first question for the court on it.
Is that actually consistent with Friends of the Earth? That's the thing that bothers me.
It isn't consistent with Friends of the Earth. I mean, it's got to be irrational not to take it into account. If it's realistically capable of causing you to come to a different conclusion, well, it could be material in any sense, because then that could apply to a value judgment materiality, which is not what we're talking about here. As I understand it, if we're into ground 3 of Friends of the Earth, we're talking about rationality. In other words, you couldn't possibly rationally take the decision without having regard to it.
Well, my emphasis, I don't dispute that is the standard.
No. Well,
As
it seems to me that what Sir Ross has said actually doesn't necessarily reflect that, and we're probably better off sticking with Friends of the Earth.
In effect, that is to say, it's certainly a test that we'd say we meet. The question is whether it was so obviously material, full stop.
Yeah.
Yes. I wouldn't push back on that as a fair proposition. My apologies, just for the pause. I've just been handed out a hard copy of the witness statement that was there. If I may just briefly just review. The point I was just clarifying, this is, and this is the primary one, it's entitled the second witness statement of the appellant. The first witness statement was just part of the statement of financial resources, so it didn't address this point, but this is the second one which is extracted. If I may hand it up to the Oh wait, sorry.
There should be 8.
There should be 8.
That's a strategic sub-area.
I think we've not got. Have you got them?
I'll rather quickly read the share. Please do share. That's fine.
Sure, it's just into come and all banner will share, yeah.
Okay. So I think I'll take this paragraph to yeah, we can go through. I think they only printed out 4. I'll send it. I'll send it. My apologies, my lord, and I'm sorry that wasn't originally included. If if I may take to the court, but to address, my lord, your comment, paragraph 3. My lord, so that was in terms of for the period in between before this letter came out, the appellant wasn't aware that they could, as it were, unilaterally send documents to the Secretary of State. The point I didn't want to make until your lordship had the witness statement before him is that paragraph 3 notes as well, part of the reason for that is the traditional... Sorry?
The inspector had said,
Is the caution, which is given by inspectors as a matter of course in terms of new evidence. So, returning to the law as is put in hell, but recognising, my lady, your point, there are 2 elements, and these are the 2 elements correctly identified by her ladyship in the court below. Was the material consideration that arose so obviously material? And then secondly, did the decision maker know, or could they have reasonably be said to have known, or should they have known about the material consideration? And those are the 2 elements of the Kynes test that we have to meet. What the appellant is not aware of is any case law which alters the duty to equate it only to material considerations which have been raised to the decision maker. Instead, we would say there is authority that contradicts that. The Tameside duty as a starting point, which places a duty on the decision maker to take reasonable steps to acquaint himself with relevant information to the irrationality standard, but that recognises that there may be cases where the parties are not telling the inspector everything that they need to hear.
Right, Tameside is a common law duty. Kite is about the statutory interpretation of section 2. The 2 are different. And if it's Tameside, and if nobody's mentioned it to him, it may be difficult to say that the Secretary of State is being irrational by not going out and asking for things when the council, who opposed the appeal, refused permission and commissioned the study, hasn't put it. So Tameside is a different strand of authority that doesn't eliminate the meaning of section 70 arguably and Kite is.
Well, I'll assist my lord on cases that do directly deal with that point, and the first one is Bath Society.
Yeah, that's a better one. Yeah.
Bath Society is found at tab 1. The authority bundle, and the facts are set out at authority bundle page 10. Or actually they start just at authorities bundle page 9 under the heading post inquiry history. In effect, Bath Society could send a case where, for a planning appeal concerning residential development on a field, shortly before the inspector for the planning appeal submitted his report to the Secretary of State, a different inspector dealing with the draft local plan recommended to the City Council that the field should be shown as open space. This is described in terms of the wording of the names of the various inspectors. This is described between A to B on authority bundle page 10. And perhaps the name that's relevant to note, because it's referenced in the later part of the judgment, is Mr. Rollinson, who wasn't an inspector, but was just the regional superintendent planner with the Department of the Environment. And in effect, what occurred is the appeal inspector was unaware of the recommendation from the local plan inspector when he submitted the report to the Secretary of State recommending permission. and the Secretary of State granted planning permission without taking into account that recommendation. Now, the Court of Appeal quashed that decision. Partly, there was a listed building argument as well, but partly on the failure to accord with what was at the time, and this is at AB 12, at E on AB 12. At the time, this proceeded, or the statutory elements they were considering preceded the 1990 Act, but they were considering the equivalent duty in section 29(1), in deciding whether or not to allow an appeal is required to have regard to the provision of the development plan and to any other material considerations. So the court here is considering that statutory duty. And what the Court of Appeal found at AB 14 is that in effect it was a failure of the duty to have regard to material considerations. What's noteworthy about Bath society in relation to this matter is about whose fault it was, the examination of whose fault it was that they weren't aware. And the court notes that on the one hand, the council could have drawn it to the attention of Mr. Rollinson, that being the superintendent planner, or someone else in the decision-making branch, and asked for it to be deferred. The fact that the council failed to do so is not the fault of the Secretary of State. But on the other hand, the appeal inspector did report that there had been an objection relating to the field, and it would have been equally easy for Mr. Rollinson, or one of his colleagues, to have studied the report to assert what he recommended, and then take the recommendation into account. And we would say, in relation to that second element, that's similar here because the inspector had noted that the report was to be shortly published in his report. And then, as the learned judge below found, the Secretary of State did have knowledge of the Arup report.
I read Bath slightly differently from you at the moment. If you go back to page AB 12, it's clear that it's material consideration. At C, it says the recommendation which is accepted by the City Council, as it has now been, could lead to the local plan containing an allocation of the site as an open space, and the proposed development, i.e. to put a block of flats there, was completely inconsistent with that. And that fell within the definition of material consideration. And then at E to F, it goes on to say, even though it's a failure to have regard to material consideration, the court has a discretion as to whether or not to quash, and in deciding whether to exercise its discretion to quash, it had regard to the factor that you mentioned at AB 14, and on the one hand it wasn't his fault, on the other hand
It's remedy.
he had the opportunity to know.
But my lord, I agree with that reading. What I'm going to come on to say though is that this feeds into, well no, it's not cited in Kydes, but that element reflects that second element of Kydes and that practical flexibility, which is it's not the case that you quash simply because a new material
But
consideration.
try to put it into the definition of the duty itself, actually. So you've got a number of things going here. They put it into the discretion of the courts to refuse a remedy. In Kydes, the question as to whether or not he knew or ought reasonably to have known was made part of
Yes.
the duty itself.
I think that's a fair reading, my lord. Yes, but I would say that it is support for the point in terms of the fact that the Secretary of State didn't know, and the fact that it wasn't, and the fact that as it were, someone could have told them. In that case, the council. In this case, the appellant didn't lead to effectively the challenge failing.
Well, the council could have told them too. They were party to the appeal and they were opposing it.
Yes.
They didn't do it either.
Yes, my lord, that is correct. But we would say
And
that
they must have known they could write in because they're the council.
my lord, I can't answer for them. But the point I will come on to is this was applied as in effect a preliminary procedural bar to us, and what we say is this is supporting that there's not an absolute rule in relation to this. Bath Society was then cited in the Baroness Cumberledge and Newitt line of cases in the High Court and upheld in the Court of Appeal. I do accept that is in the context of appeal decisions and in the context of consistency, but it is also looking at it in terms of the fact that appeal decisions are material considerations. and I'll take the court to that when I come to the Court of Appeal judgment, although it's also in the High Court judgment. So I recognise the different context in part, but I don't say that negates the principle that the court were talking about. The element in the High Court that we say, and this was upheld by, endorsed in the Court of Appeal, is the Deputy High Court Judge's findings in relation to the context of a planning appeal. And this is found at page Authority Bundle, page 166. And we say this is a relevant point to considering this appeal, which is where the Deputy High Court Judge is recognising that when a Secretary of State or one of his inspectors is considering a planning appeal, they are not presiding over a merely adversarial process. The function vested in them is one to be discharged in accordance with the law, not unreasonably and in the public interest. When considering the discharge of that function, and this is the section the appellant places particular emphasis on, however, there is a difference in practice between the position that applies until the end of an inquiry or hearing or the final submission of written representations, and the position that applies after that and until the decision is issued. Before the close of the adversarial part of proceedings, the Secretary of State and his inspectors can normally rely not unreasonably on participants to draw attention to any relevant decision. I appreciate that is in the context of considering appeal decision. But that does not mean that they are never required to make further inquiries about any matter, including about other possible decisions that may be significant. And that is an inclusion, it's not saying that's the only time. Although the prescribed procedures that apply after the close of the adversarial part of procedure do not necessarily preclude the submission of further relevant information, they are not designed to secure that the participants provide it. In that situation, further steps may reasonably be required to be taken by the Secretary of State depending on the circumstances, and there's a reference to part society. And I note, of course, at the end, that's a question depending on the circumstances. Why the appellant says that's relevant is it's recognising what will become a distinguishing feature from the West and Mead line of cases. The appellant couldn't have raised the report because it wasn't published at the time of the inquiry. And what this is reflecting, and my lord, this relates back to the discussion we were having earlier in relation to the letter. While there's nothing preventing the appellant unilaterally sending the Arup report to the Secretary of State in law, I accept that. Equally, there's nothing within the procedural rules that, as it were, facilitates that. The first formal opportunity that was presented was the one in the letter in January, which was then restricted to the MPPF and the housing delivery test. And the Court of Appeal upheld that judgment, and if I may take the court, it's at tab 10. And if I may start at paragraph 29, which is to be found on page 199. This is just a note, I do recognise the context of these cases is concerning consistency partly.
But if that's a material consideration, something else is a material consideration, by definition it can't be closed.
Yes. And so I say the principles apply, and there was discussion in both cases about what's a material consideration and the meaning therefore. So I don't say that distinguishes the principle. Turning on to then, 29 is just where the Court of Appeal is noting that they can be material considerations. Turning on to paragraph 32, or perhaps first paragraph 31. At paragraph 31, we say the Court of Appeal is asking itself or is homing in on the issue, which is the same issue here, except for if we read out previous appeal decision with material consideration after the close of the inquiry and not relied upon by any party, how should the court approach such a case? And first of all, they note at paragraph 32, rightly, the judge rejected a submission made to him on behalf of DLA delivery that as a matter of law, where the previous decision in question has not been placed before the Secretary of State by one or more parties, he is never obliged to have regard to it. There can be no absolute rule to that effect. As the judge demonstrated, having regard to a decision maker's general obligation to take reasonable steps to acquaint himself with the relevant information to enable him to decide the questions correctly. And so we say there, that is, and just if I may, because I appreciate that's worded in the Tameside approach, but the bottom of the paragraph is noting as well in terms of that relying
Statutory duty.
on the place of the statutory duty. And the court went on to at 34 to hold a number of general propositions. And again, I accept that the first principle is worded because consistency in planning decision making is important. So I accept that the context of the first principle is in that. But we would say that where the court says there'll be cases in which it would be unreasonable for the Secretary of State not to have regard to a previous decision on issues he's considering, this may sometimes be so even though none of the parties have relied on a previous decision or brought it to the Secretary of State's attention. We say that shouldn't be limited just to, as it were, appealed decisions. It shows there is a possibility in a situation that's worse than this, because this isn't the case that no one brought this to the Secretary of State's attention and the Secretary of State was not aware. Actually, the rule can go even higher than that. And just to note, the third principle that is set out at 34. Thirdly, it begins thirdly, the circumstances, my apologies, I've just lost it. Between just 2 lines above F. Thirdly, the circumstances in which it can be unreasonable for the Secretary of State to fail to take into account that has not been brought to his notice by one will vary, but in tackling this question, it will be necessary for the court to consider whether the Secretary of State was actually aware or ought to have been aware. And I just pause there because I say that is reflecting as well what will be the second element of kinds and the practical flexibility that's built into it. And the appellant is not seeking sort of some uniform rule that any consideration that arises must be taken into account. But there is the consistency in that approach and the relevance of it. Turning then to the cases, so that is the Kides line of cases that the appellant relied upon. Turning to the alternate line of cases that the respondents and the judge below relied upon to find that we weren't able to run a Kides argument. This starts with the case of West, and the general rule in West that it's incumbent on parties to a planning appeal to place before the decision maker the material on which they rely. If I may take the court, West is at tab 4. If I may take the court to paragraph 25, which is found on Authority Bundle page 67, or 66 to 67. Just to note that the factual difference, the unusual argument that was being made to the court, which was in effect, the argument was that the inspector who was dealing with this appeal under a written representations procedure should have unilaterally inquired further into the evidence of the appellant's health to see if there was further evidence supporting their case. That was the criticism that was made of the inspector. And so not only is that a slightly different scenario, but more particularly it's concerning evidence that could have been raised to the inspector at the time of submissions. It's not dealing with something that has arisen, well, it was written representation procedure, but something that has arisen perhaps after the representations were sent, before the decision was made. It is also important to note in West, and it's found paragraph 45 on Authority Bundle page 75. No, my apologies, 72. Just a recognition that paragraph 46, that fairness, you're 45, that there will be exceptional, even on this general rule, there will be exceptional cases where fairness requires. Now that's not what we're relying upon, but it shows it's not an absolute rule in West. The West rule was applied in the case of ACTA, which was again relied upon in the court below, and that concerned a challenge to the inspector who disregarded the appellant's representations that were made out of time and not in accordance with the enforcement procedure timetable. So it again concerned a fault on the claimant not doing something when they should have done it in relation to the appeal procedures. And there is just one paragraph of ACTA that is perhaps useful for illustrating the distinction, and that is found at page 130, the authorities bundle, and it's paragraph 24. Because in ACTA, the claimant relied upon the Wayne Holmes case, which was the Tides case being applied, and noting that in that case, PINS refused to consider recent appeal decisions received after the relevant deadline had expired. Counsel for the Secretary of State had submitted that the late submission of documents was a breach of the 2000 rules. Stuart Smith J rejected that submission, saying no sensible interpretation of the rules can require the submission of information.
I'm so sorry, where are you reading from?
I'm so sorry, my lady. I'm reading from paragraph 24, which is found on Authority Bundle, page 130,
Thank you.
stretching to 131.
Yes, sorry.
My apologies. My apologies for racing ahead.
Yes.
So it was reliance placed on Wayne Holmes, and just the noting from the court in Akbar that situation is entirely different from the present case, where all the material submitted in November 2015 was perfectly capable of being produced earlier. So it just highlights that factual distinction between the cases.
Yes. You say this is a Wayne Holmes situation because it wasn't available.
Yes. At the public inquiry. And the final case is then Mead realisations, and this was one that the learned judge below placed significant weight on. The findings of, as he was then, Mr. Justice Holgate. The claimant couldn't rely on an argument about planning merits, which they could have won the appeal, but were raising for the first time. If I may just go to actually what the argument was that Mr. Justice Holgate was considering, and take the court to paragraph 175, which is, my apologies,
409.
409, thank you. It's important, I think, for the paragraph that follows that was cited by the judge to understand the run-up to it. And that starts at 175 onwards. And what the court is noting is the argument that was being raised, in effect, was post-decision submissions made in the statement of facts and grounds, as to the capacity of, in effect, 13 disputed sites to take on housing. And there was these post-decision submissions, and then there was, and this is at paragraph 177, a post-decision evidence, a witness statement from Miss Catherine Venham, responding about the capacity, and in effect the argument saying before the court the capacity wasn't 4,105, but the capacity was only amounting to 50 dwellings. So the court is faced with an argument that is being raised for the first time post-decision. These aren't points that were, as it were, raised, material considerations that arose between the inquiry and the inspector's decision. And in that context, then, Mr. Justice Holgate, as he then was noting, 178, that if that argument raised for the first time post-decision had been made, it could have been an obvious material consideration. But he notes the problem faced, as Mr. Simons accepted, this argument was not put before the inspector. Redrow did not consider it to be material, let alone obviously material. It was not raised as a substantial issue, and the inspector cannot be criticised for acting irrationally or failing to give reasons in relation to an argument of this kind which the claimant did not see fit to rely upon at any stage. So the distinction there is that's dealing with an argument that, again, could have been made to the inspector at the inquiry, but was not. And if I may, at this stage, before turning in the final hour to my submission.
What about 179? He says it wasn't put before the inspector because the person concerned didn't consider it to be material. let alone obviously material, is not raised as a substantial issue, they can't be criticised for acting rashly. And you say that's only because of the inquiry context. It's only because they had a chance there, and once you're past that, you can't use it to assess a rationality. It's just
No, but it's what I was about to come on to say, which is I accept that those factors could play into a consideration of the Kydes test.
it's a factor that's potentially relevant for an
Relevant.
assessment of
Yes, but
materiality.
yes, but what we say this isn't saying, and we say this is where the judge fell into legal error, is that this is a preliminary procedural bar that prevents those arguments even being made. And if I may therefore make that point and make clear the claimant's stance in relation to the Kydes line of case law versus the Meads line of case law, and address whether there's a tension in the cases. There is, we say, a tension if, as the learned judge below is right, that as the learned judge below did, that West and Meads is applied as a preliminary procedural bar before Kydes can even be considered. We do say that as a tension in the law. But we would submit that that is wrong, and properly applied, there is no tension between the two strands of case law. And to be clear, as this is a point raised by, I think, the third respondent, we are not seeking the court to overturn any of those judgments of West, of Akhtar, of Mead. The reason we say there is no tension is twofold. Firstly, these cases, as has been set out, can be factually distinguished, as they all concern a point that could have been raised at the original hearing but was not, and that reduces, in effect, the punitive element of those cases. Those cases were concerned with where points could and should have been made, and there was an opportunity to do so. And that is also where the judgment of Deputy High Court Judge Howe is relevant for recognising the distinction between when things that could be raised at the appeal, when inspectors can assume that the parties will do it, and points that are raised afterwards. But secondly, and my lord, this is an answer to your question again, as is reflected in Mead and in 197, the failure of a party to raise a document is not irrelevant. We're not making that submission. It's just we say that it is not determinative. As set out in Mead, it could support an argument that the material consideration is not obviously material because the party didn't raise it at the time. That could be an argument that the claimant, the appellant, has to address. Though here we say that's addressed through the recognition, again in the decision of the Deputy High Court Judge, about the availability of the procedure to allow further points to come in, and the explanation your lordship now has in relation to the witness statement about being unaware of being able to do it. But of course it could also be relevant to the question of knowledge. So of course, if no one has told the decision maker, then it's of course less likely they won't be found to have known, and it will be challenging to know that they should have known. But our perhaps overarching submission, which I'll turn to in relation to ground one, is that that is the West Mead line of cases forming part of that Kydes consideration. It shouldn't be that in effect it's forming a preliminary procedural bar that prevents you from even being able to argue those points. And I would also say equally at the other end, so it shouldn't be applied as at the start as a sort of gateway in. Equally, because it factors into those two questions, is it obviously material? Did the Secretary of State have knowledge? It shouldn't be the case that if a conclusion is made that the Kydes approach is passed, the failure of the party still in effect counts against it and absolves the Secretary of State of their failure to follow the statutory duty. It forms part of the process rather than a separate consideration to it.
Why do you say there should be a distinction between a scenario A? Scenario A is the Mead situation where prior to the decision being made, a party doesn't raise a point which objectively might be regarded as Friends of the Earth material. They don't raise it, and it's then decided it's too late to raise it later. All right, so that's situation A. Situation B, exactly the same type of information, but they decide they don't, for whatever reason, raise it between the decision, between the inquiry and the actual decision that's made, or during the period that we're dealing with.
The reason why we draw that distinction is on the punitive element that runs through those cases, reflecting the opportunity to raise it at the appeal that was not taken, compared to what we accept is still an opportunity, but a limited opportunity to raise it outside.
Why is it a limited opportunity? Because there's no the only thing that limits it is the absence of a specific procedural rule that enables you to do it, but otherwise your position is completely unconstrained.
We say the limit is the one recognised by the Deputy High Court Judge, which is that it's right to say that there's nothing preventing it, but also there's nothing, unlike at the inquiry, inviting it, and there's also coupled in this case, for example, with warnings given in relation to a lack of new evidence being presented after the close of the inquiry. So there is and then when this becomes, although we say this is not determinative, the relevance then of with an unrepresented residents group as this was, it would require them to effectively disregard that warning and also not have any procedural rules on which they could hang on the ability to present something. In fact, the only procedural rule that exists says that a Secretary of State can disregard things that come in afterwards. Then that's where that distinction lies.
The oddity about the situation is this. The one person who knows all about the Green Belt in St Albans is the council. The one person who refused these planning permission applications because they broke the Green Belt issue was the council. The one person who knew all about Arup was the council. And the council has never suggested in any of the courts, to the inspector, or to the Secretary of State, that the decision should be different because of the Arup review. But you say that doesn't prevent a third party doing it, but it may be relevant to an assessment as to whether it's so obviously material, and it could, if nobody had said anything to the Secretary of State at all, be relevant to knowledge.
As a legal principle way of approaching the question, my lord, yes, that's what I say is the proper way to approach it.
The consequence isn't odd.
In what sense, my lord?
The person who knows most and should have said something didn't, and the person who says I didn't know can now come along and upset the process at a late stage. You say, well, that's just the planning system.
Well,
third parties are entitled to appeal.
Well, it bears quite heavily, and it's a hurdle I will have to overcome in my second ground as to whether it was so obviously material. Because as your lordship notes, it's the person who commissioned the report and the person who refused. But I don't say that. I say if it is an oddity, that's built in with the two tests.
It's the system, and there's nothing to stop third parties in this country. You're a democracy. They're entitled to go to the inquiry. They got Rule 6 status. They're entitled to apply for permission for a statutory review. They got permission. They're entitled to make sure that the system works properly. And the relevance of the council's stance, if at all, comes in at assessing materiality.
Rather than as a preliminary procedural bar.
Can I ask a sort of rather simple-minded question? Could it be suggested that the inspector erred in law by not having regard to the Arup report? I think the answer is obvious, but you may disagree.
I think I would just need to check the date on which he submitted his, well,
October the 24th.
yeah. There is an argument, if we were having to prove that, the way in which we'd have to hang our argument is on the reference in the inspector's report to it being shortly published. So what if it assists, and I hope I'm understanding the question, your ladyship's question correctly, the inspector wasn't directly told in the correspondence before he issued his report as to the Arup report and what it said. So I think knowledge would be, as it were, harder to prove. Where that argument would have to go is showing that it would have been reasonable to have known, because of the reference in the inspector's report, that it was to be published shortly.
But what I'm trying to get at is that it seems to me that the important consideration is finality. Now, the inspector makes his decision on the basis of the material considerations that are advanced at the inquiry. Unless you can say that he erred in law by not having regard to this, I'm at the moment troubled by the idea that the whole apple cart can be upset because the Arup report comes to light as a later stage. Because what's the remedy? Wouldn't the inspector have to reopen the inquiry and deal with it all again?
If I can answer that question, not necessarily. What the remedy would be, the first starting point.
But your point is that this is obviously material. This is it's fundamental to the classification of these sites in the Green Belt. So how can the inspector do all the balancing that he did in the first report without revisiting it?
Mother, the first step we partly know because of what the Secretary of State did in relation to the new MPPF and the housing delivery test letters. The first step is to make parties aware of a potentially material consideration by letter and seek their views on it. So it was something that the Secretary of State did lawfully in relation to the MPPF and in relation to the housing.
Before we get there, my lady's point is slightly different between the date in May when the inquiry closed and the date when he submitted his report. There was something which on your submission is an obviously material consideration, and he knew it was about to come. It's a stronger case than Bath on that. Are you suggesting that the inspector himself acted unlawfully, or do you say it just doesn't matter?
Well, the primary submission would be, Elisabeth, that it doesn't matter because you look at the time of the decision maker rather than the recommendation that's made by the inspector. But the secondary submission would be, if as it were we had to as part of that question, we would say that the inspector acted unlawfully because, as your lordship indicates, of that recognition of that point. But if I may expand that first question, which is whether in effect you need to show that both the decision maker and the inspector were wrong in law to, as it were, succeed on these points. We would say if that is the case, then it potentially sanitises or closes down any ability for a material consideration that arises after an inspector has written his report, but before the Secretary of State makes his decision, which is often a period of time, a significant period of time.
It depends on the nature of the material consideration, because if you're the Secretary of State and there are other decisions by the Secretary of State in relation to inspectors' reports which raise similar issues to the one you're considering, it's a material consideration, it's potentially a material consideration for the Secretary of State. Oh, look, I'm about to make a decision that's inconsistent with another decision I've made. But this case raises a different question. This is not to do with consistency of decision making by the Secretary of State. It's to do with an inquiry which has been held. People have had their chance to make their representations. The inspector has made his decision on the basis of the material that was properly before them at the inquiry. And my concern is, if your argument's right, it's difficult to see what remedy is other than reopening the whole thing, and that's inimical to finality. So can you assuage my concern?
So first of all, in terms of the practicalities that would occur, or the action that the Secretary of State should have taken, as I say, I appreciate, and I'll come on to, the reopening of the public inquiry may have been the eventual destination, but it's not the starting point. The starting point is, as the Secretary of State had done, the letters making the other parties aware of it and allowing them to make submissions. Now, it could have been the case, therefore, that the Secretary of State had said, well, I've made you aware that this is a potential material consideration. I've heard what you have to say. I don't consider it material for these reasons. And that could have been the end of the matter. yes, of course, I must accept that this could have led to the inquiry being reopening, and in fact, of course, the second respondent raised that as a point. But what I do say is that the practical costs that would have flowed from that is what's required to, as it were, meet the Secretary of State's statutory duty to have regard to material considerations. I don't think, or I'd respectfully submit, it can't be right to effectively say it would be too costly or time consuming to accord with my statutory duty to have due regard to material considerations.
I'm just a practical person. I just want to explore what the logical consequences of the argument are.
Yes.
Can you just remind me where the paragraph in the inspector's report is? I thought it was 330, but it's not, where he says the council in its closing submissions, I think, said that the report was due shortly.
Yes, my lord, that is at supplementary bundle page 61, paragraph 300.
This was the summary of the case for the planning for the local planning authority. So the local planning authority was told by the council who were opposing these appeals there's going to be a new Green Belt review to be published shortly. I just wonder whether the inspector might be able to say, well, they've not come back and said to me, this is a game changer, I can carry on. Wouldn't he expect that if the local authority, who knows they can write in and say there's something material, and they've warned the inspector it's coming, I wonder if this isn't a bit more than like need at this stage, where if they want to wait until the Green Belt review, or they want to tell the inspector, hold on, something might come which would be a game changer, shouldn't they have raised it, just like the argument of Redrow and Mead?
Perhaps they should have raised it, but like in Bath Society, it was noted that they perhaps should have raised it, but they didn't. That's the paragraph in Bath Society where it notes the council could have raised this, the council could have.
That goes to discretion, of course, yeah.
Yes, but ultimately that plays into then what's become the Kyde's test in terms of knowledge and in terms of obvious materiality.
You say it's just simple. The law is that if it's a material consideration, you have regard. If the council fell down on its duty, if the poor third party just didn't realise it's had a chance to raise it, and if it is obviously material, you say, well, that is the law, and that must be what happens.
Yeah, my lord, in effect, the failure of one party doesn't absolve the Secretary of State of their statutory duty at the end of the day. Of course, that failure is relevant and could be highly relevant to whether the Kyde's test is met, whether there's knowledge or reasonable knowledge, whether it's obviously material. But as it were a knockout blow, we say it can't be right that the failure of any party to raise something can, as I say, absolve the Secretary of State of their statutory duty.
Sorry to bang on about finality, but just looking at paragraph 300, I mean, was the inspector required to wait until the housing requirement under the new local plan was known before he made his decision? Where does it end?
Well, the answer to that would be, if the new local plan was adopted before the decision and the housing requirement became known, then yes, we would say that could have been an argument, but that hasn't happened here because that process was a long way moving through. So I appreciate the principle.
I mean, when is the inspector entitled to draw a line and say, well, these things might happen in the future, but I've got to decide I've got to make a report on the basis of what's in front of me now.
Perhaps, my lady, I can address it this way. The inspector's role, as it were, is to get the report, making a recommendation to the Secretary of State. At that point in time, the duty is then on the Secretary of State. So where does it end? It ends between the time up to the Secretary of State makes their decision. Within that time period, if something arises that is a material consideration, to just choose an extreme example, and one that was here, if the Secretary of State hadn't written the letter about the new MPPF and no party had raised it, but the Secretary of State had made a decision on out-of-date policy, just because no party raised it and because it emerged after the inspector wrote the report, we wouldn't say that could be, as it were, an answer to the failure to have regard to national policy.
Council also said that 301 is really more relevant to your second ground. There's been a lot of reference to the south side, which had been allocated in the withdrawn plan, and so it that the front that had been withdrawn, so the plan wasn't relevant. But it says in any event, we are applying a different, more stringent test compared with the test that's applied when deciding to release land for the Green Belt. We've seen the test in framework for a planning field with very special circumstances. What is the test for deciding whether to release land?
I think it's exceptional. So I just need to test, but I think it's exceptional circumstances, and it is a different test.
It is a weaker test.
I think it is. I think it is a weaker test.
Well, so you can release land
there is laws.
more easily than you can grant permission for planning development.
Yes, my lord. The response I'd just make in relation to that, though, is those were caveats and points recognised by this inspector in the report. He noted that it was asking a different question. It didn't prevent the inspector making it an important consideration.
So the fact that, I forget if it's the appeal site A, the fact that appeal site A had been said to be the least suitable for, and therefore more likely to be released into the wild, so to speak. The fact that it satisfied that wouldn't be the answer to whether you could grant planning permission for development. You'd have to go further and show not only exceptional circumstances, but very special circumstances.
Yes. But as part of that very special circumstances consideration that the inspector carried out, the important consideration was that this was an area that was most suitable in the district to be developed. So I'm not pushing back on any of the points your lordship makes, but what I say is that isn't an answer to the inspector's reliance on the SKM review.
But it does mean the SK review can't be determinative by definition.
Material factor.
It's just a material, but I would just use the language of the decision maker. It was an important material factor. Melody, if I may just return to your point on the, and sorry, with an eye on the time as well, and I looked at my 1 o'clock timetable, on whether you need to focus in on the inspector rather than the Secretary of State as a whole, and look at subdivide the process, as it were. We would say that because it's the statutory duty lies on the Secretary of State in this case as the decision maker, they are the relevant body that you need to look at. And we'd respectfully disagree that it is a determinative question to say, well, first, was the inspector unlawful, and then does that unlawfulness carry through to the Secretary of State?
I don't think I was
No.
suggesting that, and if I was, that was certainly not what I intended. I just was exploring with you the relationship between your submission and the desirability of finality.
Yes, and my lady, how does this sit with the principle of finality? Well, it sits in two ways. Firstly, it sits or it accords with the principle of finality because it only applies to material considerations that arise before the decision. So once the decision is made on the material considerations that existed at the time, that is where that finality comes in. And so it's not the case of, for example, in Mead, these were arguments raised for the first time after the decision. So that's how finality is present there. But secondly, and it comes back to the point raised earlier, the importance of, as it were, finality of the inquiry, if I may put it, compared to finality of the decision. We don't say that finality of the inquiry, we've had the cost and time of an inquiry, and if this has to be taken into account, we need to reopen that inquiry. That shouldn't define or determine the scope of a statutory duty. And I return to what I think are important words in Kynes. The practical flexibility is added by the fact that you need to show that this was something that was known or reasonably could have known. It is a stringent test, we would say, and we've come on to submit that we meet it. And that therefore accords with that principle of finality, that it's not any consideration that arises after can simply require a public inquiry to be reopened. So where that stringent test is met, the time and the cost of a potential inquiry is justified, we say.
I'll just ask one further question about the authorities, please. Is there any authority which deals with the period we're concerned with, i.e. Between the end of the inquiry and when the Secretary of State issues the decision letter, which deals with material other than other decisions of inspectors?
I think I have to accept the authorities before your ladyship today all relate to either appeal decisions or to inspectors' reports on local plan exams. I would make the point that in relation to CIDES and the cases that apply to the local authority level, there are, I believe, cases that include, as it were, non-reports or things like that. But I think if it assists your ladyship, I think I'd have to accept the cases that I've cited.
Okay, that's very helpful.
Turning perhaps then, and a number of these have obviously been ventilated already, but turning briefly to my submissions in relation to this. In relation to the first ground, we would say the learned judge was wrong to apply Westmead as a preliminary procedural bar, which is what her ladyship did at paragraph 67 of her judgment. That is by reliance on the West and Mead principles. And we'd say that her ladyship was respectfully wrong to do so for the 2 points I've noted, the factual differences between those cases and the relevance that has for the legal principles. Again, this is a point we've touched on, so I will just summarise it. The West-Mead line of cases examine the issue from a point of procedural fairness and the importance of following procedure and the practical consequences that arise if parties don't, because these were all points that could have been raised at the original hearing. While the CIDES cases all examine it from the scope of the statutory duty, because these are cases where the material consideration couldn't have been raised. And we say the distinction, that removes the punitive element, and the distinction there is important, as reflected in the judgment of the district judge in the Baroness of Cumberledge case. And her ladyship's judgment that the claimant was procedurally barred from running a CIDES argument, as they themselves didn't raise the point, we say narrows the scope of the Section 70 duty, which has been held to go so far as to require the Secretary of State to have regard to material considerations that in fact no party have placed before them. And I note there the Bath Society and Baroness Cumberledge cases. And there's also, her ladyship's judgment undermines that Tameside duty of sufficient inquiry, because that also exists on decision makers. And we say that is undermined if it's predicated on whether it was a material consideration which had been raised to the decision maker.
Can you just remind me, is the Tameside duty, or her judgment of the Tameside duty, a ground of appeal?
It is. It's referenced in my skeleton. So the ground of appeal.
The grounds of appeal is on the grounds of.
Well, no.
The skeleton.
The grounds of appeal are in relation to that Westmead operated as a preliminary procedural bar, preventing relying on CIDES. So no, I accept it. It's aimed at the CIDES.
It seems to be the Tameside, the duty of inquiry, very high bar, irrationality, nothing to do with the interpretation of Section 17. It doesn't seem to be one of your grounds. And if nobody comes back to him, whether or not they could or couldn't, or they could or couldn't, very hard to see how he's irrational at common law by not following up on things that have been mentioned. I'm sure lots of things were mentioned in what must have been deeply fought inquiry. So unless Chainside is part of your grounds of appeal, I wonder whether it's right to rely on it.
I appreciate that, my lord. It's noting perhaps just the point on the legal principle, but I accept that. But what the appellant would say, and I make this point at paragraph 58 and paragraph 59 of my skeleton, is that in holding that the failure by the particular party challenging a decision to raise a material consideration as a preliminary procedural bar, Her Ladyship has introduced the absolute rule that the Court of Appeal in the Baroness Cumberledge case held did not exist. But the effect goes further because the unusual element of this case is that Her Ladyship accepted that the Secretary of State did know about the Arup review and that the second element of the Kyde's test was met in this case. That's paragraph 92 of her judgment. And what, therefore, the effect of Her Ladyship's judgment is that a decision maker is entitled to ignore a potential material consideration that is known to them because one particular party has not raised it. And we say that is one of the practical dangers of equating a statutory duty to what has been presented by the parties in a case. Paragraph 60, I think I've noted.
It can't be right because the case is about other of the respective reports. So that, I mean, that isn't going to be something that the other parties are going to raise, is it? Anyway, it's as we know about it.
My apologies, my lady.
I'm trying to make a point that helps you, doesn't matter. So.
No. I do.
It's a pretty good point, if I may say so. That what my lady is saying is that if you look at the line of authorities that relate to other decisions, well, that will be out with the knowledge of the parties to the underlying inquiry, but within the knowledge of the Secretary of State, and that's inconsistent with the proposition that the Secretary of State can ignore something that they know. Because the other parties haven't drawn it to their attention.
I thought unless you was there, I agree.
It's my fault for not making the point clear.
No, my lady, my apologies. I agree. That is one of the points. Yeah. Paragraph. I think the points at 60 and 61 of my skeleton have been ventilated and discussed in response to the bench's question, so I won't repeat those. But if I may pick up the point at paragraph 62, which is that there would be detrimental practical consequences that flow from Her Ladyship's judgment that a party must have raised a material consideration to rely on Kydes. Because one of the points that is unclear is whether that ratio would apply only to a party that had an opportunity to raise a consideration as a formal party to the appeal, or any potential claimant. If it's the former, that the ratio only applies to those who have the opportunity to do so as a formal party, then we'd say that would introduce a high degree of artificiality to the Kydes principle, as it means that while the appellant would be barred from running the point, a resident who was not associated with the Rule 6 party would be able to run the point and say, as a member of the public, well, I don't know why people didn't raise it, but this is a point of concern to me, and so that creates a practical consequence of issue. The alternative is that it applies to all claimants, so any member of the public would be unable to run a point because the particular parties in front of the inspector failed to raise it. And again, we say that returns to the unlawful, we say cutting down of the statutory duty to simply those points that have been raised in the inquiry in front of the inspector. And the point being, as the Deputy High Court Judge recognised, it's not wholly an adversarial process as well, and there are duties and obligations on the Inspector and the Secretary of State. That is why we would say it is wrong, it was wrong for Her Ladyship to introduce it as a preliminary procedural bar. I've already touched on this point, but just to expand it, it's unnecessary, we say, because those elements that are raised in West and Mead, the action or inaction of the party who's raising the point, will be relevant to questions about whether it's so obviously a material consideration. Your Lordship's point on...
Well, should we really look at that? Because even if you're right and you should have raised it, you've still got to show it's so obviously material.
Yes.
In the sense that it would be irrational
Yes.
for the Secretary of State not to look at it.
Yes, and that's my second ground, which I will move on to now. So, we say that the learned judge was wrong to find that the Arup review was not so obviously material. And we say that because it flows from two separate points. The way in which the first respondent treated the SKM review, and then the findings and the role of the Arup review itself. And those 2 points together form our argument as to why it was so obviously material to take into account. In terms of how the first respondent treated the SKM review, and I should particularly say the second stage of the SKM review, was not just that it was a general material consideration that had to be taken into consideration when reaching a view onto the acceptability of a proposal in Green Belt terms, but it was a very specific, highlighted, important consideration that because both sites appeared in sub-area S8, that was considered by the second stage review to be the most suitable Green Belt area in the district for development. This returns to the distinction the appellant makes as to what is the important point. The strategic point is being relied upon, which is that the inspector found that the housing would have to go somewhere in the Green Belt. And so it was clearly important that the evidence before the inspector was saying, and this is the most suitable place for it to go. So it can't be said, as is sometimes the case in these cases, this was a minor material consideration, ancillary point. The inspector and the Secretary of State in their decision letter highlight it expressly as an important consideration.
But you say that, but when you read through it, he does say that. We've gone through 520, 530, 533. He then comes back at 534 to 542, and he's dealing with site-specific. He's got a planning application or an appeal in front of him, and he's got to decide whether to grant permission for that application or allow that appeal for development on that site. And he does it by looking at the site. And I know he's got in his mind that this is the most suitable review, the Green Belt review, though the local plan never actually got to allocation stage. And he makes his findings. And the thing that troubles me is 550. I mean, he does seem to be saying what the Green Belt review says accords with my view of appeal site B, where the damage seems to be harm or the harm seems to be greater. And if that's the case, well, it would matter what Arup says, because his assessment on the ground, in every sense of that phrase, was, yeah, this is suitable, a suitable location, given the very special circumstances that he has found. That's the difficulty that I've got. And might have led to a different consideration. Somebody else might have wanted to look at it. But to say it's irrational not to look at a proposed allocation which hasn't been tested when it's not critical to the question issue, that's the problem.
And my lord, let me try and grapple with that issue. What we say is it can't be said that the important consideration outlined before we go to the site specifics doesn't feed into the eventual overall judgment. Clearly, what that important consideration is telling the inspector, as well as looking at site specifics, is that housing has to go somewhere and this is an appropriate place for it. Now, that could affect the weight that's given to, in effect, the harm. That could affect the weight he gives to the benefits, because this is housing going at the place that's most suitable. It clearly played, and I don't just say some role, an important role. So we're not challenging those site-specific views, but what we can't say is that if the inspector had been told that there are other more suitable areas in the district for development, that the inspector would have said, despite the harm I find, these things aren't quasi-mathematical. It's not, he's not adding up harms with benefits. As an overall planning judgment, yes, these sites may be, there's a distinction under S8 between Appeal A and Appeal B, but actually there are 87 other sites I'm aware of which the council are looking at that are more suitable for meeting housing development in the district.
Yes, but you've got to show not that he's relying on the SKM. I know you say it's equivalent. You want to say it's irrational not to look at something that's been drafted but hasn't been tested, which would go to the release of land which is on a lower test. In a situation where, yes, he had strategic issues in mind to start with, but has then gone to look at the individual sites and consider that individual site against the harm. That's the difficulty you've got, I think.
But just, my lord, to pick up on one point, the fact that it was going to a different question and the fact that it hadn't been tested could also be said above the SKM review.
Doesn't matter, because you've not challenged the fact that he took into account the SKM and it shouldn't have been. You're saying he had to challenge the, he had to include the Arup.
But the point being, we can't know what this inspector, as it were, would have done with the Arup review in front of him. But what we can say is, the thing that immediately preceded it, which was of the same status, a final report, part of an emerging local plan process, was an important consideration.
Yeah, he used it to check his own evaluation of the site. And he regarded it as an important consideration that it was regarded as suitable.
Or my lady, the most suitable.
All right, well, the most suitable of the 7 or 8 that were looked at in that particular review. I mean, that doesn't negate the possibility that there might be other suitable sites out there, even more suitable sites. But of the 7 or 8 that had been considered to date, he found that that was the most suitable, which indeed is what it said. But at the end of the day, he's using it as a checking mechanism for his own evaluation. And that, as my lord says, is the problem.
My lady, I know that point. We would respectfully disagree that it's purely done as a checking mechanism, because I think that the inspector is finding that there is evidence. The evidence before him tells him that of everywhere in the district, this is the most suitable site for housing development. The point of the material consideration that follows is that this isn't the most suitable site in the district for housing.
I'm slightly troubled by this, but it's probably because I don't know enough about planning. He's got to decide whether this appeal should be allowed, whether this application for development on this site should be granted. Answer, starting point, no it shouldn't, it's green belt, it's harm. And I give substantial weight to that, is what he said. Then he says, but there's a housing crisis in St Albans, certainly he said an affordable housing crisis in St Albans, and that outweighs the harm to the green belt. He's not, is he deciding as between 8 possible sites which one should get it? He's deciding whether there are special circumstances which justify building on this site.
But what the important consideration plays in is in that balance of there's a housing crisis in this district. Part of that consideration is, and the best place to meet that housing crisis is in the most suitable part of the green belt. Because that's what his paragraph says at 531 is at 533, that there's a recognition of development in the green belt. So your lordship's housing crisis point, which I accept is the point that weighs in favour of granting permission, is informed by the fact that this is going to have to be met somewhere in the green belt. And the SKM review is telling him, and is evidence that he relies upon to say, this is the relative suitability of the place to go. If the inspector...
What bothers me about this, sorry to interrupt you in full flow, but relative suitability. I mean, the question is it suitable or is it not suitable? Whether it's relatively suitable with other sites may be a factor, but at the end of the day, it's not the tiebreaker. it may well be that as a matter of planning judgment, if he had the Arup report in front of him, he might have said, well, there are others that are regarded as more suitable, but that doesn't make this one unsuitable, and therefore I'm still going to give you planning permission. We simply don't know.
But my leadership concern is the one I was trying to articulate. That's the problem, isn't it?
I don't believe it is, because I can perhaps try and answer this in a hypothetical way, and I hope it's helpful rather than unhelpful.
Yeah.
It goes back to, I believe, your ladyship's question earlier in the morning. If the inspector had both of these reports before him, because that's what the decision maker had. The decision maker had knowledge of both of these reports.
No, the knowledge, you've switched from had the reports before him to knowledge of. He never had the Arup report in front of him. He never knew what it said.
So you're dealing with the hypothesis that he might have had it.
Yes.
Right, yes.
If the inspector had, or any decision maker had these two reports in front of them, an earlier report that said this is the most suitable area for greenbelt release, and a later report that expressly superseded fully the earlier report that said this is not suitable for greenbelt release, we'd submit the inspector would have clearly been irrational
To have relied on the first one.
Yes.
But then put that to one side, and the next question you've got to ask is, I've got an application on this site for 391 houses. Is it greenbelt? Does it cause harm? Yes. What weight do I give it? Substantial. I don't know if you could have given it more, but it's substantial. And he's done that by reference to the purposes of greenbelt and so on. And then he says, are there special circumstances that outweigh that? And he says the answer to that is yes. He couldn't, could he, have said, well, it is harm to greenbelt, there are special circumstances, but I prefer them to put it on a different site which hasn't been considered or allocated yet.
But what the inspector could have done, and what the decision maker could have done, is say there are harms to the greenbelt here, there are benefits, but as I say, and case law says, it's not quasi-mathematical, it's then a judgment as to whether those benefits clearly outweigh the harms.
But could he take account of a different site in deciding that?
Yeah, he could take account of the fact that the evidence was saying there are more suitable sites in the district. It would have
Well, he
been...
could if he chose to as a matter of planning judgment. What weight he might give to it is another matter. It's speculation. What concerns me is how you can say it would be irrational not to. That's what you've got at the moment to persuade me that it would be bonkers, to use the vernacular, not to take this into account.
Because, my lady, I say, again, setting aside whether the inspector did have it in front of him, the question under Kides, I think, is that if they were in front of him, and I do say it meets that high bar of irrationality, where a decision maker relies on a superseded report that comes to a directly opposite conclusion as the report.
On a different question.
Sorry?
On a different question.
Oh no, but both reports were dealing with the same question, which was which land should be explored for release in a local plan exam.
Yes.
So the SKM and the Arup were dealing with the same question, they had the same role, they had the same status. And so we know, the one thing we do know is that this inspector has on the SKM report relied on it as an important consideration. And the point that's been relied on it is that this is a suitable area for development. If the inspector had the report in front of him that said...
He would have concluded it was an unsuitable area for development. Is that, you've got to go that far, haven't you?
He would not have...
That he could not rationally have concluded, despite having been there and done his own site visit, that this was a suitable area for development in the Greenland because of that report.
I don't think I need to go so far as to say that it would have led to permission being refused, because the court can't exercise a planning judgment. But what I say we can say is that that important consideration would not exist. And if that important consideration would not exist...
So the important consideration is, just for benefit of my note,
Yes.
that it was the most suitable site of 8, or that it was a suitable site?
That it was, on the evidence before the inspector, the most suitable site in the district.
All right, so the important consideration which would not exist is that it was the most most suitable site. Right.
That's the most suitable site for release from the green belt.
And future development.
Right.
And that the submission I'd make is that the inspector couldn't have reached that conclusion on the Arup report.
But isn't, I'm sorry, we're going around in circles perhaps, but at the end of the day, what he's got to decide is, does it do harm to green belt? Yes. Substantial harm. Is it outweighed? Yes. And does it amount to special circumstances? Yes. Even though he's comforted by having this report that says if it's got to go somewhere in the green belt, this is it does the least harm. At the end of the day, what he's got to decide is whether this land should be released because of this housing crisis. It's only a build-up, isn't it?
It is only a build-up, but all we can do is base ourselves on the language that you use, that seemingly an important building block to that build-up is the important consideration based on the second stage review. If it wasn't playing an important part in the overall consideration of very special circumstances, it wouldn't have been worded in this way. The point
Well,
is
if you hadn't regarded it as a material factor, your argument would have got it off the ground at all.
I think that's fair, Manny.
Yeah.
The unusual under this is that it is specifically highlighted.
You say that the fact that he did regard it as an important material factor means that if that factor, if there is no longer any foundation for that, and there's something out there that shows that it's no longer a safe assumption, then he should have been required to correct that before he reached his decision.
Yeah.
That's really what it boils down to.
Yeah. And we'd say, because, as I say, it's the two. If it helps a lady to illustrate other times when I'd struggle perhaps to get off the ground in terms of this claim,
Yeah.
if the Arup review had been, as it were, had recommended them for release but in combination rather than isolation,
Yeah.
had made, as it were, weaker conclusions, then again, struggling to meet that high bar. The two elements that we say the two unusual elements that we say makes this so obviously material is the importance placed on it by the inspector and the direct reversal of that important consideration in the Arup report.
I've got a couple of things about that trouble me. One is the Arup report has never been tested, so we don't know whether it's right or wrong. But secondly, when we're looking at materiality, I understand it's a matter for the court. We must decide. And I understand your forensic arguments about the comparison between the two. We must decide, was this report so obviously material that it would be irrational for the Secretary of State not to decide to allow us appeals on site A and site B. And I still come back like a cracked record, I'm afraid, to the one group of people who really do know whether it's material is the council, and they haven't taken this point and they haven't been concerned by it. And that's what bothers me. They're much more likely to know about the green belt than us, with respect to my lady's case.
Can I ask you a question, please? If you look at the conclusions, the inspector's report on what redundancies that the inspector made boiled down to was the weights which he gave to the harm that would arise to the green belt, substantial in both cases, and then whether or not that's the substantial weight that he gave to the harm to the green belt was outweighed by very special circumstances, and he held that it was. And at the moment, I'm just not following how looking at one report rather than the other would in any way affect those judgments, because those are planning judgments about what is the level of harm to the green belt, number one, and number two, are there very special circumstances which outweigh that?
Let me try and assist if I may.
Please.
The weight that is being given to those elements is informed by the important consideration that the inspector has set out, which is that this is the most suitable area in the district to develop. So that is the starting point. That is the way in which that important consideration, because weight is a matter of judgment, but we know an important consideration in that judgment is the important consideration, this is the most suitable area. That conclusion, that this is the most important area, is predicated on the SKM report. And that's the evidence that the inspector relies upon to form that. By the time of the decision, that evidence has been superseded by an equivalent set of evidence, but a more up-to-date one, produced because of the failings of the second stage review, has taken a more comprehensive and granular approach and concluded that the important consideration that played into the very special circumstances conclusion no longer existed.
Just looking at the planning balance, it can't affect the substantial weight to the harm, can it? At all.
No.
Nor really the substantial benefits from the scheme in terms of housing provision and so on. Then he says the harm by reason of inappropriateness and other harm is clearly outweighed by other considerations so as to amount to the very special circumstances. You have to say that in some way, this on that side of the planning balance is going to feed in negatively to the finding of very special circumstances, don't you? I think you do, because it can't affect his assessment of harm. He's already said it's substantial weight, which is as high as you can get.
Yes, although these aren't, as it were, defined terms with a quantum.
It's a judgment.
These
It's
are
planning
a
judgment.
metaphor for his judgment of what he wrote. But the reason I pause, my lady, is it could have played, though, in terms of the very substantial benefits in housing provision. Because not only is there a benefit of delivering housing, but one of the benefits is this housing is going where it's most suitable to go in Green Belt terms. That was why I was pausing, as I'm not necessarily sure it's limited to just other considerations.
Where do we find in the report when he assesses the benefits of the housing that the benefits are benefits because it's in the most suitable housing, in the most suitable area?
Well, I think I know the answer, but I'll just read through to confirm.
If it helps, I can't find it anywhere in the section from 585 to 594.
The answer which I was just confirming is you don't find it in that section, I would accept, but you do have to read obviously these reports as a whole, and it must be something the important consideration is going towards.
Well, I was wondering whether, going back to 612, whether you were going to submit that it could potentially be a material consideration that indicates that planning permission should be refused. Because what he says is there are very special circumstances and there's no conflict with policy, which there isn't. It would be in accordance with the development plan, yes it would, because it's still emerging, and there are no material considerations that indicate that planning permission should be refused. I mean, is it your submission that it's conceivable that, and we don't know, we don't have a crystal ball, that finding that there were other more suitable sites might have led him to find that there were such material considerations?
It could do, my lady. The issue we've got in this is recognised. What we know for sure, it was an important consideration. I appreciate how that important consideration filters through.
What it means is very different. I might say something, this is very important to me, but you don't know what that means without going on and reading the record. He's reassured, he thinks it's going to be all right, but he did his highest, because he thinks it's in an area that's going to cause least harm, so he can relax. He then goes through for each site what's the harm to the green belt? And the answer is there's still substantial harm to the green belt. And then he says, are there venues? Well, we do need housing. And then he says, is that a special circuit? A very special circuit? Yeah, I think it is. So although it's an important consideration, is it an important consideration in the issue that he ultimately actually has to decide?
Yes, because we would determine that in your lordship's fund there of, and this area does need housing, it needs housing in the green belt. It's going to have to meet its housing need in the green belt, and this is the most suitable area to do it.
That's not the reasoning, though, is it?
Well, that's what we say.
You say is the reasoning.
If we read 531.
I just don't think you can stop there. I think you've got to read
No,
534, and
no.
I think you've got to go up to 550. And 550 just says dead against that on appeal side B, and I thought that was the worst one that did most harm. I might have got the sites the wrong way round.
Except we have to read the report as a whole, but there is these are the considerations. If we go, these are all the considerations on Greenbelt. So we're within the Greenbelt section of the report. These aren't context setting. We say this is recognising the strategic point. Yes, the inspector goes on to look at the site specifics in terms of Greenbelt harm, and we're not saying that necessarily that conclusion would have affected the Greenbelt harm, as your ladyship has noted. But we say where it clearly would be relevant is in the weight to be given to the provision of housing in this location, because this is the most suitable site in the Greenbelt to do it. And then that plays overall, as I said, the reason I keep returning to it in terms of the quasi-mathematical, these aren't simple points where you say, well, there are three substantials on one side of harms, and he's having to come to this overarching judgment taking into account very special circumstances. And what we would say is the report read as a whole fairly is the important consideration of the relative suitability is an important consideration in that overarching planning judgment. What I appreciate is that I can't point to where after it affects a weight that changes, but the question for the court is not, as it were, that this would have changed the decision. It's whether, and we say perhaps to raise it on that hypothetical, if the inspector had these two reports in front of him, would he have been able to rationally prefer the second stage review to the Arup review? And phrased in those terms, because that is what we say should have happened for the statutory duty to be accorded with. And we're not asking the court to come to the view that said, well, because the court cannot exercise its planning judgment in that way. But we are saying on that analysis, that's what makes it so obviously material. The way in which it was dealt with. And sorry, my lord, may I just pick up, if I may, and I appreciate the time as well, and I think I've covered the submissions unless I can assist further. I'll just turn my back before I do. My lord, you mentioned the point about the testing, and the one of your points of concern was about the fact that the app review wasn't tested. Just to note, the SKM review wasn't tested either because the examination never. Oh yes. If I may just turn my back as well. Unless I can assist the court.
Well, Mr. Riley-Smith, I'm conscious of the fact that we've asked you a lot of questions and put you on the back foot with some of them. I don't think that you should feel under any sort of pressure or disadvantage. So if there's something that occurs between you and your legal team over the short adjournment that you want to draw to our attention in the 5 minutes or so after we come back, then please by all means do so. I don't think it's going to materially add to the afternoon. So I want you to feel that you've had a fair opportunity to explore everything that you want to explore with us. I'll say 2:05.
Court rise in favour.